Specifically, the case law says.
Whoa. How the hell do you jump to that conclusion? So if you show me a case, Mr. Martel, that says under those circumstances, the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time. You need to file a written motion. How long is that going to take you?
Judge,
How long is that going to take you?
Judge, certainly.
How long is that going to take you? If it's not going to be a lie, go for it.
Judge, respectfully.
No, you lied to me.
Today, we're in Judge Simpson's courtroom, and we've got an attorney who walked in ready to win the hearing by straight up manipulating the court. He lies directly to the judge's face like he thinks confidence counts as evidence. The wild part is he genuinely believes nobody will notice the giant holes he's leaving behind. But Judge Simpson is sharper than every trick this attorney tried to slide past him. You can literally see the moment the judge realizes this guy is bluffing without even having a hand to play. Bold, messy, and unintentionally hilarious, watching an officer of the court fumble this hard. Do you think he actually rehearsed this, or is he just hoping the judge won't check the record? Let's go ahead and dive in.
Yeah, Darren Dwayne Wilson, sir, please stand and give your full and complete name for the record.
Darren Dwayne Wilson.
Thank you.
Judge, if I may, very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, the sole basis that the people intend to introduce quote-unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that the counsel is attempting to.
Well, then I'll let him finish, because I don't know, it did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People Be Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says.
Whoa. How the hell do you jump to that conclusion?
What, Judge?
Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue, because I think it's a. Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter. Certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position.
Does that case clearly apply to search warrants?
That it's not limited to search warrants.
But that isn't what I asked you, Mr. Martel.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge, what I'm.
Just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they've made a finding.
What in the world is happening here? Because the attorney walked in looking confident, but opened his mouth and delivered nothing but confusion. He starts talking like he's unveiling some grand strategy, but all that's coming out is pure nonsense. The judge is trying to follow along, but the attorney isn't even connecting his own dots. He keeps throwing out search warrants like there's some magic shortcut to victory. Yet, none of them have anything to do with this hearing. And then the judge asks him how they relate. He phrases like he got caught cheating on an open book test. He's referencing cases he can't explain, facts he can't tie together, and legal points that don't belong anywhere near this argument. The courtroom slowly shifts from listening to wondering if this man is even in the right case file. Judge Simpson is showing almost superhuman patience, trying to give this attorney every possible chance to make a coherent point. Meanwhile, the attorney is bouncing between topics like he's scrolling through his brain, trying to find something that makes sense. At this point, it genuinely looks like he prepared his argument in the car ride over. The more he talks, the less clear his point becomes, and you can practically hear the judge's inner monologue screaming. This is the kind of performance that makes you question if he reviewed even one page of the record. Watching him spiral like this isn't just awkward, it's a full-blown legal melt.
Judge, specifically, this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant, because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martel, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
Judge, so acknowledged, I would say that Burrell is applicable, and I would also humbly submit, Judge, that the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion. So I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
How long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. And please, this most honorable court, Edward Martel, P 85051, on behalf of Darren Dwayne. State your name once again for the record.
Have a seat. So, Mr. Martel, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding refusal started with and I hate using the word, but it's true, it started with a lie. Then, Mr. Martel, you continued with your lie regarding the import of the case of People versus Burrell. You cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
We're deep into this hearing, and the attorney still hasn't managed to tell a judge which specific case he's referencing for all of these supposed search warrants. Naming a case is like step one in any legal argument. Yet, he's treating it like optional homework. Instead of citing it, he keeps dancing around it like he's hoping the judge will just fill in the blanks. But here's the real twist. The reason he won't name the case is because Judge Simpson never handled it. He's trying to gaslight the judge into believing he did, which is not only bold, it's a surefire way to torch your own credibility in record time. When the judge calls for a recess, you just know what's coming. Someone's about to get exposed. And once the judge checks the records, the entire argument collapses instantly because none of what this attorney said lines up with reality. Imagine trying to bluff your way through court while the judge literally has the case history 2 feet away. That's not strategy. That's self-inflicted damage. You can see the exhaustion on the judge's face as he realizes this hearing has turned into a fact-checking mission. The attorney keeps scrambling, trying to twist his way out of the lie he created. But you can't wiggle your way out of something that's sitting in black and white on the record. At this point, his...
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully,
No, you lied to me.
okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not. But
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations of the context. The main argument is what it is. And certainly, Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it. Anything else, Mr.
Judge, just very
Martell?
briefly, and I certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martell, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recused for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor. And I certainly had no intent to mislead this court. Or in fact, I'm going to pull the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth. If it's the position of the court that it's not, certainly, Your Honor, we will move forward with your denial and we're prepared for.
I have not ruled. You will hear my ruling loud and clear.
Yes,
But do
Judge.
not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024 at 12 noon.
Thank you, Judge.
Waste of time for everyone involved today because this hearing didn't move an inch. The attorney's lies didn't help his client, his argument, or the case. They only dug a deeper hole. He wasn't advocating. He was trying to bend the court to his narrative, and it showed instantly. Judge Simpson is too sharp for that kind of performance and picked up on the inconsistencies the moment they slipped out. The fact that the judge still let him file his motion and be heard later is unbelievable considering how badly he fumbled this hearing. Most judges would have denied it right then and there after catching him in a lie. It's genuinely sad because the person who suffers the most here isn't the attorney. It's the defendant stuck with him. And when he begged the judge not to pull the record after getting caught, that was the final nail in the coffin. Attorneys have a duty under Rule 3. 3, to be truthful to the court, and this guy treated it like a suggestion. So, what do you guys think? Should the judge have ruled on the spot, or was waiting for the motion the right call? Let me know down in the comments. Thanks so much for watching. Don't forget to like and